Okay, so I think we can start. And do we have to wait for the recording? Or... it's on already. Welcome, my name is Giacomo. I'm an assistant professor here at the University of Amsterdam, and my work is broadly speaking on EU law and market regulation. I'm delighted to chair this panel, which explores property, one of, I guess, the main institutions of capitalism, and how race and gender and different conceptions thereof can transform our understanding of property. And more broadly, in this panel, we mobilize different approaches, both interdisciplinary and historical, to understand the role of property in contemporary capitalism. And I think what our speakers share is really how they show the real work that property does in capitalism, how law, culture, and ideology interact to support and justify property. Beyond, I would say, this vague rhetoric of co-constitution, this is really, I think, the type of work that really shows the mechanisms. Let me introduce our panelists, who are Parvathi, Menon, and Yoon, Kang. So, Parvathi is a lecturer at SOAS after experience teaching and researching across the world in the National Law School of India in Bangalore, the University of Gambia, and Helsinki, where he's been for a few years before SOAS. Parvathi is a scholar of international law, and she adopts Marxist and third worldist approaches to illuminate questions around the notion of protection. I think the article you shared, protection of both racialized people and property. She's also interested in the gender dimension of international law and the political economy and history of international law. One article that she shared with us, and I invite everyone to read, is Negotiating Subjection, the Political Economy of Protection in the Iraqi Mandate, which is on the Trail Review. Our second speaker is Yoon, Kang, who is an associate professor at the University of Warwick after having held positions at Kang Law School, the University of Lucerne, and also the Max Planck Institute for the History of Science. Her research indeed is truly interdisciplinary at the intersection of legal and social theory and epistemology and the history of science. Yo's core research is intellectual property law, which again she studies by drawing on scholarship in anthropology, social and literary study, historical epistemology, political economy. Just to mention some of the recent work, the article that shared with us, Patents as Capitalist Aesthetic Forms, which I take to be about the work that patents as cultural sign do in contemporary capitalism. Some of the work is also more policy-oriented, aimed at shaping a more equitable intellectual property regime. I also want to mention that Yo serves on the editorial board of both Economy and Society and the Journal of Cultural Economy. So we start with our speakers will give us their own initial thoughts on the topic. So, sorry.
Thanks very much. I can't start without thanking all the people who organized this and put it together, so particularly Ivana, Alicia, and Prachi. And thanks to all the other speakers for kind of these really illuminating two-page documents. I didn't realize 2 pages could say so much, just like reading through all of the things that have been discussed. So thanks for that, and it's a great model that you kind of set up, Ivana. So my own work. Yeah, I mean, so it's one is of course to think of law and political economy, and I've already talked to Ivana about it, and I think Rob has said enough that I have nothing left to say. But it's important to understand how the language of LPE, and Corinne, I love you, but this is the law and political economy. I mean, is really kind of it's an American response to the post-structuralist critique, right? So we are thinking of post-structuralism, which emerged as a response to Marxist critiques, and then you find that in order to not revert back to the language of Marxism, you kind of have to create a more palatable language, which allows for Americans to say that, we are not going to critique or push back against post-structuralism, but we're not going to be Marxist. So I think there is that sense which permeates the language of LPE. So, which I think, again, in Europe and in many parts of the world that I come from, Kerala and India, we don't really need to kind of rely on, we already have the language of Marxism. So we can use it, right? So that's kind of my first thought on what the language of law and political economy really mean. And in my own work, I I focus on racialization. So like Giacomo kindly introduced, so I work on the concept of protection, and so much of my work is really a way to kind of think of historically through the long 19th century, how the protection of racialized people and the protection of property were very much intertwined. But in doing that, one also needs to kind of, I think the first panel really helped us to think about it. You can't just call it mutually co-constitutive, or you can't just use these words to run away from what the work that it's really doing. And I think for me particularly, I look at the long 19th century as a way to break some of these temporally and spatially, to kind of break that long 19th century into modes of thinking about what that relationship really looked like. So I start from the slave economy, I start from slave colonies, and to focus on the work that law was doing there in protecting labor. So we think in that sort of Trinitarian sense of labor, land, and capital, and to not think only of the dualism of labor and capital, or to obsess over just land, but to think of how law was able to separate the interconnectedness between these three things in order to ensure that that protection of racialized people and protection of property worked. And in order for it to work, my work is to show how that separation was really kind of concretized through the legal language. So in doing so, one of the ways that I look at that interconnectedness, I look at how law separates the interconnectedness, but that interconnectedness exists beneath the surface to enable the social relations of race on the one hand and property on the other hand. And so they have to speak to each other. So therefore, this process of appropriating and distributing surplus value appeared across this 19th century as isolated and autonomous, right? Production of value and by these disparate actors. So we start to think of the slave colony, the West African protectorate, and the mandate system as being like very different models that in some ways, kind of was a mode of progress, right? Like you've now abolished slavery and now you're working with another model, but it's to show that much of the language of protection was to say that I will protect the enslaved person whose labor is important, right? And need to protect the enslaved person. But then the shift in the West African protectorates later on is to say, I will protect the landed property. But what we miss in all of this is that the interconnectedness between labor, land, and property, and capital keep working in each of these moments. But law, at least this is my sense, that law allows us to think of them as separate factors that exist without the other. So law tells you that I will protect labor without really thinking of what that protection of labor is doing, or I will protect landed property without really thinking of what that landed property protection is doing, or I will protect capital or investment without really understanding what's happening in the background. So it's that kind of invisibility of the triage which I think law enables, and that's my work in a way to understand. So of course, when we think of property, we can't possibly think of it without thinking of labor and value and so on and so forth. So of course, they're all interconnected. So that's another interconnection which I don't look at particularly, but of course we have to be able to kind of parse the nuances in how these differentiations are created. And I think one of the questions that was asked was, how does law create these differences? So one we can say is by just kind of, again, by that separation and thinking of each of these as individual problems that need to be solved. But another way is, law also creates these very innovative kind of legal languages in order to ensure that everybody sort of feels included in that system. And I look at a very long history. It's the long 19th century,
Sure.
but I also trace. I think she's like, yeah, that's it. Yeah. So I think that, so I look at various ways in which that difference is structured. I look at it through the language of obedience and allegiance, which is a way in which protection as a as a kind of reward for people to be part of the polity was very much tied to the role that they play in the mode of production. So whether it's thinking of them as laborers, or whether thinking of them as landowners whose land was, obviously not cultivated well enough, or to think of them as those who wanted to protect capital or the flow of capital, right, back to the metropole. So it is to think of these interconnections and to think of how law enabled the shift. And I think it's really important in that long 19th century to not think of the relationship between racialization and property as existing in a simplistic binary, which we can then explain through all of these temporal and spatial kind of locations. Simply because it doesn't work the same way. With talking about protection of enslaved people, it's very, very different from talking about the protection of the natives in the West African protectorates, and entirely different from protecting inhabitants in the Iraqi Mandate, right? It's a different, so we cannot employ the same language of racialization because it just doesn't work. We have to think of racialization as adapting to the needs of those moments, which in my account tells the story of labor, land, and capital. So it is to really, and in understanding how that racialization or the language of racialization changes, we then can kind of make sense of what property itself means in each of those. Because property itself means, labor is like one's own property, and we think of land as property, we think of capital as property. So what do we mean by property? I mean, it is social relation and whatnot, but it is in understanding that relationship that we really make sense of what any kind of study on race or racialization really does across that long 19th century. So I think, and I obviously draw a lot from Rob's work, and it's also drawing from his work is also to say that it's important to not, one is to draw that relationship, but also to not over determine that relationship in order to understand as what work it does in different spaces. And I chose Brenda Bhandar's article as the article that I kind of put forth as a reading, where she relies entirely on Cheryl Harris's whiteness as property in order to understand property as a mode of abstraction, and and of course she thinks of it through race and whatnot. But one of the limiting factors, and again this is something that I've been talking about quite a bit, is of whiteness as again a very American-centric kind of idea, created again from a context that's extremely important. So I'm not saying it's not, which is enslavement, but then beyond that, it doesn't really work in the same way. So we can't think of whiteness as something that can be just constituted and thought of in, which exists in a very specific moment as something, but then does not really mean the same thing later on. So I think that kind of fits in with my idea of racialization, as we have to keep thinking of how it adapts and how it's needed in different modes for different reasons in order to facilitate the protection of property, which itself means so many different things. So yeah.
Thank you, Parvathi. Yeah.
Thank you. I'll start off by saying that I think, so this is a panel of property. I will talk about intellectual property, which I don't really think of in the same way in the social effects as what one might call real property. I think the fundamental premise from which I'm starting out is that intellectual property is a total legal fiction, like many other legal areas, but particularly so intellectual property, because how do you actually even, well, I guess it's a kind of abstraction like many other legal forms, but I think there is something really so slippery around the notion of intellectual property that has always puzzled me. So one way to try to understand what intellectual property might be ontologically, because it's so slippery, is to go about it by seeing what kind of epistemic techniques and practices are employed in order to stabilize a certain kind of meaning drawn around some kind of knowledges that might be identified as being similar or different, and so on. So I think that's a kind of like an internalist way of looking into the legal form itself. And I think there are different ways to go about it. So one might be just a very close textual reading, as we teach our students, interpretation and so on. But I think also often, because then you will find tautologies and paradoxes, then we draw upon other kinds of, I guess, explanatory models. And in my area of what I specialize, especially in patent and relationships to science and technology, is to look at the works by historians of science, science and technology studies, but I think also just broader scholarship on representation in particular, because how do you actually represent the intangible? So I think these kind of insights from humanities are really crucial to understand what intellectual property actually does, so in actual practice. But I think I actually moved a little bit away from that in the last years, in the sense of trying to understand more the external social lives of intellectual property. So why do people value intellectual property, or how is intellectual property actually mobilized in certain kind of modes of social valuation, financial valuation, and so on. So I think the kind of political economy angle, if you want to put it in that way, is really interested in the way that patents as legal forms themselves and the very, I guess, intricate techniques that constitute the legal forms shape the capitalist economy, I think, especially now, because patents in the way that we know it are very much capitalist creatures, starting out with the model of the machine, industrial revolution. Before that, they were not seen as property rights, they were privileges. So there is a very close correlation between different forms of organization of, well, let's call it social reproduction. Might also want to call it economy, but I guess creation of certain kind of values that are then being attributed broader social value and monetary value. So I think there is a very close correlation between the legal form and certain modes of, I think, variations of capitalism. So I'm not so much interested in that these relations exist. I think we're beyond that point of showing that law and economy co-constitute each other. I think it's a bit of a, yeah, I think it's a moot point. I mean, we're really trying to show how it actually happens, right? And I'm interested in the actual dynamics of the relations and the mode of their composition. So one way I try to go about that is I look at why people value patents. So it might be seen in a normative sense, but also, you know, in terms of market relations, strategies, but also financial valuation, which then led me to the, I guess, a kind of an inversion or like a cannibalistic way in which law itself becomes not separate from political economy. So it's, I think, the label of law and political economy doesn't always apply. I think so in that case study where I see how patents have become financial assets, you see that law itself is being gained and law itself is becoming part of the financial capitalist speculative economy itself. So how does gender and race relate to it? Like, I have to be very frank, I didn't actually foreground the notion of race and gender for the reason that I think it is pretty obvious to many critical scholars in IP that the knowledge that is being recognized as being legally recognizable knowledge is premised on a very specific Western scientific mode of knowledge production, but also modes of representation. So there have been long-standing debates about the status of traditional knowledge, why these can't attract a certain kind of IP rights or IP protection. So in a way, for me, I've always felt that this is not something that anyone would dispute, but to be honest, in the last, I think, 5 to 8 years or so, I think maybe I took this too much for granted. So that the race and gendered notions of knowledge and what counts as valuable knowledge, especially, it is actually not all that obvious to people. So that's something I think what where I think I should actually work more on, but it actually goes beyond just kind of law and political economy scholarship, right? Because where do you actually start? We might have this whole debate about why women are underrepresented in STEM, like why certain knowledges do not count as scientific knowledge. Then, going to university education, the way that certain kind of technological values are very much tied to private capital, the rise of venture capitalism, private equity, tech grow imaginaries. And we know that women, especially in these areas, are either playing along the game of being one of the lads, or they're being quite systematically sidelined, as we see in the current debates around AI. So I think it actually goes way beyond the framing of law and political economy. If you want to introduce notions of race and gender, I will actually talk about some examples where this was tried, but it hasn't been particularly successful, especially at the intersection of legal scholarship and then policy work. Also, I was actually quite wary of being associated or being part of a so-called critical IP scholarship that does address explicitly notions of race and gender, but it is more along the lines of that kind of scholarship is liberal. It's more along the lines of why do we not have more women inventors? Or why did women invent, but they were not granted patent rights? So if I actually have a profound fundamental problem with the existence of IP law in the transnational way it is right now, with many of the doctrines itself, like why would I encourage other people that might be seen as perceived or read as different to participate in a system that I profoundly have a lot of problems with? So I did not want to associate or be complicit in that, and it's very hard to stake a way in which to do critical scholarship where you're not paying lip service to token representation or diversity as in a very, very superficial way. But this is not to say that IP law has nothing to do with gender and race. The legal concept of what is novel, what is non-obvious, what is the work, what is original, I mean, they're profoundly embed notion of who is the rightful inventor or author and so on. But it's something that needs to be actually shown in very, very detailed. Recording. Are we off track right now?
Go crazy.
Okay. So that's all great, but I think we need to actually attend to the specificities of these different intersections. So I think some of the most interesting and sophisticated works that have done this work of showing the, let's say, the racialized notion of the heroic figure of the inventor actually have come from outside the law. They have actually engaged with a lot of legal archival material. So they come from history of science, history of technology, economic history, musicology, art theory, and gender studies. And they're actually mainly written by scholars working in the Anglophone Academy, and I would argue not continental Europe. From within IP law scholarship in Europe, it's dominated mainly by doctrinal teaching and scholarship, and I've not observed much interest in thinking about notions of gender or race. I think one moment of bifurcation where the different, I guess, pedagogical as well as scholarly aims thus became apparent was the COVID-19 crisis and the debate around the church labor. So for full disclosure, I was heavily involved in it. And I think it was probably the first time where IP scholarship became quite kind of fully publicly politicized, and there was public open disagreement around the TRIPS waiver and the notion of vaccine inequity, because what you saw was exactly the countries, the geographical divide between so-called IP capital-rich countries and then the, well, I would say the people who have to actually pay in order to get access to IP capital, which were typically in the global south. So it's been, I think what's really interesting is to compare my subfield of law. I also work in legal theory and also at the intersection of law and science, is that the debate around how integral the notions of gender and race are, the discussions are so much more advanced in other legal subfields. So I look at international law, I look at labor law, don't know about EU law all that much, I have to admit. But in IP law, like the critical voices that are attending to these concerns are not necessarily from the mainstream or even the broad bulk of what one might call critical IP law scholarship, because like that kind of critical is seen to be, you know, I mean, it's still not, it's not contesting the legitimacy of IP law as a whole, but they want to improve it. And for me, the idea that you can improve it by allowing more people to have access to monopoly rights, it's deeply problematic. So that's where I'll stop. Thank you.
Thanks a lot to our speakers, and